Hey everybody, I'm Adam Rossen from the Rossen Law Firm, and we just were able to listen to Mehdi talk about some great things on these cases. And I'm here really to talk primarily about the investigation stage. What do we do, right, as criminal law practitioners when we have a client call us or come into the office and talk about being either investigated or arrested for a sex crime. And we'll talk a little bit about the investigation stage, that process up through filing charges. And then we're going to fast forward a little bit and talk specifically about the deposition process as well at the second half of my presentation. So with that, let's begin. Now, who am I? So I'm Adam Rossen. I'm the founder and CEO of the Rossen Law Firm. We handle criminal DUI defense, sex crimes, white collar, pretty much anything criminal related. And there's my little bio about me, but you can definitely take a look and read that and hit the QR code if you'd like. But really, this is not about me. This is about you folks and really just educating and talking about the best way to handle these cases and have a successful outcome for our clients. So as I said before, really the order of investigations and really not further than just investigations, but just sex cases, right? Usually there's a police investigation that starts with number 1, and 2 and 3 can be reversed in some situations. So, and I'm going to go over that in a few minutes, but it could be the prosecutor could make a filing decision, which can then lead to an arrest and a surrender, or after the investigation, the police will then make an arrest, or we will coordinate a surrender, which will then lead to a prosecutor's filing decision. So 2 and 3 can be be interchanged, and then we go through that discovery and deposition process, which is most of the time the longest process in these cases. And then the last stage would be a plea resolution or a trial stage. So really that's the basic general order. Not too different in order than most criminal cases, except for the vast majority of criminal cases that we see, there's an arrest made immediately on scene right away, where in these sex cases, the vast majority of cases, there's an actual time extended timeline where there's supposed to be an investigation. Of course, we always say supposed to be because as most criminal practitioners know, the police don't do good or detailed investigations in most cases. Now, the client interview. So this is essential. When you first meet with a client, this is a golden opportunity to be able to influence the case against your client from day one. And above all, you must establish trust with that client. In any type of case, but especially in cases as severe, as sex cases, right, where there's literally the client's entire future could be in your hands. So you must establish that trust. You must get the client to be honest with you, to be opening up and giving as much detail as possible. Now, the first thing you need to really ascertain is, has that client been arrested and charged, or have they, just been contacted by law enforcement, or have they not even made contact or been contacted by law enforcement? But if they have, you need to know who, right? Who made contact with the client? You must get the law enforcement officer's information as soon as possible. As you may know, police officers are allowed to lie to their suspects, our potential clients. They're allowed to pressure them in some ways, and they often do in these cases. So we must make contact immediately, right? We need to discuss with our client, well, what evidence do they have, right? What evidence needs to be preserved? Are there cell phones? Are there text messages? Are there videos? Right? All of these things that are there witnesses? Who are the players in this? We need to get all of that as soon as possible. The next thing is, well, what evidence, right, would we maybe need to subpoena, right? So as we're talking about certain things like, again, text messages, videos, maybe social media messages and back and forth, we want to screenshot it to really preserve it, but then do we need to actually subpoena this from the company to make sure that we can get that either now or later, and possibly at a trial or throughout the case. So, and deciding when to do those things, because there's strategic advantages and disadvantages of getting a subpoena too soon. And really, who else was involved that needs to be investigated? Start building your theory. So is this a situation where the couple is going through a divorce, and all of a sudden, 5-year-old Johnny is claiming that, or mom is claiming that 5-year-old Johnny said that daddy touched him in an inappropriate way, but really mommy wants to move with her new boyfriend, 5 states away, right? So we need to discuss theories of this with your client to see, well, hey, do we need to investigate mommy and her new boyfriend and find out, what are the real reasons of this? So all of those are extremely important. And when we have the client interview, it's all about collecting details. So classic, who, what, why, when, where, how, right? Just basic questions that we learned in grade school. But we're going to want to know, right, again, why were they charged? What were their theories? Where did these things take place? Right? Was it at your client's house? Was it at somebody else's house? Was there anybody present that could be a witness, or could be either a witness to the allegations or a witness to say, hey, I was there. Nothing could have possibly happened because there were 7 people in a 700 square foot apartment, and we surely would have known if something happened, right? Okay, when, and building that timeline is so important. Is this a late report? Is this something that happened, years ago, right? Is this something that happened recently? When did our client become aware, right? Is the client still in touch with the alleged victim? All of these things are very important for understanding our strategy throughout, especially throughout the investigation stage. Are there any documents, right? Does the client have anything, related to the investigation or charges, any kind of documents whatsoever? Again, it could be something like an email. It could be a lot of different things. Is there maybe, was there any documents or messages passed back and forth, or even, we've had cases where a diary was kept, right? Is there something like that where there's a diary? And where is your client in the communication with law enforcement stage? Was your client at work and a cop, a sex crimes investigator came and left a business card and, on his door, and he came home and saw that? Or did he have a full-blown conversation over the phone? Or did your client already go in and give a statement, right? You need to know exactly how much has already been done, because sometimes our clients, they have great intentions, but they often, make tremendous mistakes in their case. And you must let your client know immediately, no more. Everything runs through us. Everything, every strategic decision, every communication with law enforcement, any communication with outside people, they need to understand to watch their text messages, and just, this is not the type of situation where your client needs to be talking to multiple people about this and about what's going on. You need to make that very crystal clear from the beginning, right? Now, you also have to set client expectations, and that's kind of what I was going about and really talking about, up until now, is just making sure the client understands who's in charge. Okay, client plays a very big role. The client and the attorney are partners in this, but the attorney needs to be the one steering the ship, needs to be the one making the final strategic decisions. But as in things, in all walks of life, communication is key. And I believe the attorney needs to effectively communicate with the client and explain, this is the plan, this is what we're going to do, how we're going to do, why we're going to do it, especially the why, and make sure that the client's on board and there's that trust and give and take. And as far as, what are we trying to do during this investigation period? So number one whatsoever, no uncertain terms, is you must be that buffer, that shield between your client and law enforcement. Okay, at our firm, we kind of equate it to being Captain America. Captain America's weapon is his shield, and we tell clients, we are your shield. Everything runs through us. We want all communication. We are shielding you from law enforcement. And then again, as we stated, gathering the essential information. Those are the really two. So as we talk about shielding the client, right? They have a right to remain silent. They have a right to counsel. And what we do at our firm is we've seen over years and years, and I was a former prosecutor, that in most situations where it's really concerning that law enforcement may be lying or may be exaggerating, usually it's about either probable cause to search or start, to search, or it's about what a client said to them, right? Maybe this was an excited utterance, or as they made initial contact before a body camera was on, or before there's a statement at the station, the client said, "I know why you're here," and blah blah blah, right? And so what we do to combat that is we give clients an invocation of rights sheet, basically where they're able to very easily invoke their right to remain silent and right to counsel. And all it is it's a sheet on our letterhead. It has all of the attorneys' names. It has our office number, which is answered 24/7. The client signs it. And that way, we don't have to really stress or worry. The client's instructed to just, if something happens before we can prevent it, or without our knowledge, the client can just hand that over and give them the invocation of rights form and just say, "No, thank you." And now we're creating evidence. So instead of, right, because I've seen over and over and over again, rights waiver forms that the police are supposed to have not be used, disappear. An officer in a deposition will say, "Oh, I didn't have any on me." Well, the officer's not going to forget their gun or their badge when they show up to work. So why should they forget a piece of paper, a rights waiver counsel, that can easily be in their briefcase, in their car, in their stack of papers, right? So that's why we go ahead and we take that next step and we actually create it ourselves. Okay. Now, I know Mehdi talked a little bit about Rape Shield and those different things, but when we're investigating, during this investigation period, don't be afraid to investigate the victim. We must investigate the victim, the alleged victim. There's a huge difference between what we can investigate, what we can actually do, in a deposition and through discovery, and what's admissible in a court of law, right, at a trial or a hearing. So when we talk about Rape Shield, really that's only as far as what's admissible, in court. But you must investigate these alleged victims, and we're talking teachers, friends, disciplinary figures, especially when we're talking about children, but also when we're talking about adults. We want to know coworkers. You have to dive deep into the alleged victim's mind. And the only way to dive deep into their mind, right, to find out possible motives, is to dive deep into their life and know exactly what's going on. Now, a controlled call is a very big part of these investigations, especially when we're talking a late report or when there's no physical evidence. The controlled call is essential in these cases. And most people have no idea what a controlled call is, that it's allowed, or that it can even be admissible against them. So what a controlled call is, usually the alleged victim will be at the police station. She'll be there with the detective in a conference room. She'll have a listening device that's recorded, that's attached to a tape recorder, and she'll call, she'll call your client. She'll call the accused, and it'll start off as a normal call, and I use she and he, but of course it could be any different pronoun, and they're not really trained that much. But it's a quick thing where they get some basic training from the police, and what the police will tell them is, look, make it natural, make it normal. Start off just getting them to talk to you, right? You don't they don't want you to hang up on them, and then you start to confront them with accusations. And a lot of times it's, listen, Bobby, what you did to me was wrong. okay? I need you to admit it and tell me. I need you to make amends, and all I need to know so I can sleep at night is that you're sorry, and I will never call law enforcement. I don't want to bring this to the police. I just need you to tell me that you acknowledge what you did went too far, okay? And that's a very typical controlled call. You know, and even, you know, we have to tell our clients to look out for it, right? Because a lot of clients will just say, well, I don't know what you're talking about, right? But they won't flat out deny it. We have other clients that will yes somebody to death. You know, okay, well, if you think I did anything wrong, I apologize, but, right? And that could just be a person yesing somebody to death, trying to get somebody off of the phone without saying, you know, you're a terrible human being, you're lying, I didn't do this, I don't want to talk to you, click, right? So we need to avoid that because those are things that prosecutors and police are still going to use against you. And obviously the worst type is when somebody just flat out says, yes, I absolutely did it, you know, right? So we want to prevent that as well. And you know, that's why you must find out at what stage in the investigation your client's at, and you must let them know about the possibility, the strong possibility of a controlled call. Now, we're talking about preserving evidence. You know, we want to review and save cell phones. I've had situations where I've literally taken our client's cell phone and we've sent it out to our expert witness to preserve, to download through either Cellbrite software or some of the other softwares, and really will we preserve that right away? And I say, listen, Bobby, you know, you're going to buy a new iPhone, and because you know, you're not going to get an iPhone in prison. So I'm going to take your current iPhone, you're going to buy a new one, we're going to send the current one to your expert and secure all of this, you know, information, right, and preserve it for later for the case. And you're going to, again, want to make a decision about a potential, you know, subpoena ducis tecum and where that's going to be, you know, if you're going to do that now or not. And really the reason that we talk about the subpoena ducis tecum so much is, at least in Florida, as criminal defense attorneys, we don't have the subpoena powers ourselves, which, you know, different story for a different day, but I think that's kind of crazy that a civil case, you can have full subpoena power for really whatever you want when you're fighting over money. The prosecutors have subpoena power, the law enforcement does, but our criminal defense attorneys don't. We don't have automatic subpoena power. We must go to a judge and request a subpoena. And so if we're going to be doing that, well, we have to tip off the prosecutors to our strategy, to what we want. So, you know, there's always that strategic decision made, and at least if you can preserve the evidence yourself, then you can always make the decision on a subpoena ducis tecum, especially if we're talking about social media and cell phone text messages and all things like that. You can always make that decision later, you know, especially if it's much better if it's your client. Now, if it's something where it's the alleged victim's information and you have 100% conclusive, you know, proof from your client that that will actually exonerate them, well, then that's something that either you could discuss with the police officers and tell them to go get it, or we can even then go to a judge and, you know, and ask for the subpoena ducis tecum. And when you do that, you know, law enforcement is going to look terrible in front of a judge. So with the prosecutors, because, you know, you're going to basically tell the judge, hey, this is evidence that we think will exonerate him. They're not even willing to go get it as pursuant to their investigation, right? So that's a strategy on, you know, if the situation merits it, that's a strategy that we've done in the past that has worked very well. The next slide is more about, or it goes into depositions, but what I want to do before we talk about depositions, I want to talk a little bit about some of the in-between steps between the client interview and that initial investigation that we had a few slides ago. than depositions. So I'll move back to that original slide right here. Let me see if I can move back for you guys. Oh, actually, I don't need to move back. But basically, what it is, we're talking about a prosecutor's filing decision and an arrest or surrender. And when we have these steps, what I tell our clients is, look, worst case, cops come, kick down your door, find you, they're waiting for you at work, whatever it is, and they just arrest you. And again, that's why we always want to be, we want to make sure the police officers know that we're on the case in a friendly, professional manner, and that everything needs to go with us, right? So we don't want that to happen. We don't want the cops to just bypass us and make an arrest. They don't really want to do it themselves because there's officer safety issues. Above that, well, if the law enforcement officer has made a final decision that they have probable cause to arrest and they're going to make the arrest right away, well, then we at least want to coordinate a surrender. We want to be able to surrender the client on his or her own terms. We want to be there and present always to make sure that there are no, statements given or any violations by the police. We want to make sure that there's a bondsman ready, that we're ready for first appearance court if the client has to go to first appearance court. We've coordinated all of those potential issues where, if the client doesn't have a place to live, we've secured that to make sure that the client has a place to live and survive. And, last thing we want is, especially, really any client to be arrested by surprise, especially at work. So we don't want that. So that's a step above. And then what I tell our clients, the best thing to do is see if we can push off the arrest decision and push it to the prosecutors. So if we can convince the police officer, hey, you may have probable cause, you may not, but regardless of what you do here today, the prosecutor's office is going to have to decide, do they file charges? Do they reduce charges? Do they not file charges and drop it all completely? Because the prosecutors are the ones who decide what charges to file. So because this is not a traffic stop that leads to a cocaine arrest, right? This is a longer investigation. Officer, just send this over to the state attorney's office and let them continue their investigation and give me a chance to talk to them. And so why do I want this? Well, number one, it delays a potential arrest, which is always good, but really it gives me an extra bite at the apple. So we've already been negotiating, and trying to, convince a police officer to dismiss and be done with this case. Well, now we can do it with the attorney, and it's a much different level. It's an attorney to an attorney level instead of an attorney to a police officer. It's not, the attorney's not just looking at this as, hey, do I have probable cause to have him arrested? The attorney's looking at this, do I have a reasonable likelihood of conviction? Am I going to spend my time, effort, right, and energy to prosecute this case if there's no way that half the things are going to be admissible in court, or I don't have any good chance to win? Or maybe the prosecutor might not believe and trust the alleged victim and might not believe it makes sense. The prosecutor's job and the police officer's job are different. Police officer's job is, do I have probable cause to make an arrest? That's it. And so the prosecutors are thinking about so much more. So we've had great success in cases about getting the detectives to not make an arrest and send it right to the prosecutor's office. And then when we can get in lawyer to lawyer, we've had great success in getting cases dismissed. So those, steps 2 and 3, arrest, surrender, or prosecutor's filing decision are important, very important steps in the process that I definitely wanted to cover a little bit before we went into the deposition phase. So hopefully that really helps you folks. What we can do now, as far as going into when we're taking depositions on these cases, you must be prepared. This is not a, let me go ahead and take a look at the police report, 30 minutes before my deposition because, excuse me, because this is a possession of cocaine case, and I've done, handled thousands of possession of cocaine cases, okay? You shouldn't do that anyway in those type of cases, but you especially don't want to do it in these type of cases. Now, you're going to want to be extremely prepared. As I said before, you need to look at the offense at the statute. You need to pull the jury instructions. I love looking at jury instructions. I personally think the jury instructions are easier and better to understand than the actual statutes, and so I love looking at the jury instructions and picking those apart. You're going to want to look at the sentencing statutes because there's a lot of cases where, on the sex crimes, there's so many different enhancement levels and different things that if in a deposition you can, knock some of these things out that maybe a detective or a prosecutor thought they would have, you can knock out years off of a person's life and enhancements just through the depositions. And of course, you're going to want to, beforehand file a statement of particulars if there's a child victim, because you really want these, the information and the allegations to be as limited as possible, so you know exactly what you're going to have to be preparing to defend against. You want to put that onus on the prosecutors, because the prosecutors will just throw everything else at you. There may be a long statement, there may be many different allegations. Well, we need to really, chip away and limit these things as much as possible. And a good analogy that I use is I'll tell clients, I'll say, well, have you ever been to a fancy wedding or a party and you've seen a beautiful ice sculpture of a swan? Well, it didn't start that way, right? It was originally an ugly block of ice, and somebody chipped and chiseled and maybe took a little Dremel and shaved it and polished it, and over the course of some time, that big ugly block of ice became a beautiful swan. And in cases, especially sex cases, it's the same exact thing. If you can't blow the case out in the investigation or the pre-filing stage, well, then we're in for a battle, and it's a slow chip, a slow chip, a slow chip. So part of that statement of particulars is just chipping away and really trying to hone in on what the actual allegations are and what the prosecutor's trying, or is going to be planning on trying to prove against your client. Through the discovery, you have to know that discovery backwards and forwards, not just police reports, but all witness statements. You want them audios, videos. Don't rely on transcripts. Transcripts are often wrong. You're going to want those audios and videos. If their medical exams have been done, you need that. You need to get CPT's file as well, and you need to have, like we talked about earlier in the investigation stage, records of the victim. That could be phone records, employment records, school records, and whatever evidence that you've preserved yourself. And as we talked about school, right, especially when we're talking about children, we want to know who reported it. Was it a teacher? Was it a parent? Did they tell any of their friends? Why did they tell their friends if they did? What kind of social groups are they in? There's different social groups for a 6-year-old than a 10-year-old versus a 14-year-old. Have there been any grades or disciplinary issues? If so, what are they? When did they start? You must build that timeline. And of course, here in Florida, any evidence that we get, if we don't plan on using it, well, that stays between us. So we're not under any of those discovery obligations where we have to give the prosecutors things if it actually is bad for our client. So we're going to want to get that. More often than not, it actually helps us, and it helps our case. And if we have adult, alleged victims, then we're talking about their work environment. Not just their current work, their former place of work. What's their work history? Has there been a long history of behavior issues, discipline issues, erratic behavior? We like to go wide and then narrow it down. Well, specifically at the timeline, right? We're looking for things, had there been any changes? And if there hadn't been any changes, right, but this person continually had, right, bad behavior, well, then that can be really good, because unfortunately for us, the detectives and the prosecutors, they'll be focused on the immediate timeline, the here and now, and they'll say, well, her job performance suffered. Okay, but did they know that for 10 years her job performance was bad, and he or she was fired from 3 other places prior to this? So that's important, that prosecutors and police will never know. They're never going to bother to get. Did they tell any coworkers? Did they tell any family? And as defense attorneys, we know the more times you tell a story, little things change, right? Well, it's their burden and their responsibility to make sure that it's accurate. So if little things change, well, then big things can change too. And that attacks and really, reduces and lowers the alleged victim's credibility. And that's what we're looking for. That's another big part of what we're looking for in these cases. Now, we're going to want to make sure that we're talking about Sexual Assault Treatment Center now, the SATC, on these cases when you have these. So these will be involved in cases that are usually not late reports. But there'll be a video statement of the child. We need to review that statement backwards and forwards. You need to know everything about that statement. And we keep going back to timelines. Well, investigation timelines are very important as well. When we're doing, investigation timelines, when the police or the Sexual Assault Treatment Center, they're doing that, there's such a high suggestibility, even more so than in photo lineups. And, over the years, the process and procedure for photo lineups have changed quite a bit, because there's been study after study that's shown that they're highly suggestive. Well, the same for this. And we've seen many cases where the officers involved, they will spend 2 hours speaking with the alleged victim. They'll spend another hour speaking with the alleged victims, if it's a minor, the parents or the complaining parent. And then they'll go on video, and we're talking about a 10 to 20 minute, videotaped statement. And we have no idea what was discussed prior to for an hour or two, right? So, they're trained in the suggestibility of children. And you don't want these people to know much about the case, kind of like, the same way photo lineups. Most departments have changed so that way the officer who's conducting a photo lineup knows nothing about the case, is not the investigating officer at all, and there's no body language issues, there's no suggestibility issues. Well, it's the same in this. You want to make sure that they don't know much at all and that they're asking open-ended questions. They're not asking leading questions. Unfortunately, they get it wrong all the time. And, we as defense attorneys can never substitute, their word for the truth or just trust them. They are not to be trusted, and that's that's why we must investigate over and over and over again, and really don't be afraid of being aggressive with them, because we have clients to represent. So we really need to go at them, and be hard on them. And, it's the same, whether it's a sexual assault treatment center and a minor child or the police officers. These police officers, they're trained, but they're not experts. What does training even mean? They went to a 40-hour course. Okay, so if you went to a 40-hour course, that's 5 days of your life. Okay, you completed 120 course hours. Fine, that's 3 weeks of your life. Just because you've been a sex crimes detective for 10 or 20 years doesn't mean you know what you're doing, and it doesn't mean you're doing it the right way, okay? So we never, ever just trust what they're doing. And you're really going to want to pull policies and procedures of law enforcement. You're going to want to have those documents and compare their policies and procedures for how they interview, whether it's a sexual, assault victim, alleged victim, or a child minor alleged victim. How they're supposed to do the interviews. You're going to want to look at their internal policies and procedures, which are public records, and compare that to what you're seeing on video. And you're going to want to be prepared to question them about any pre-interviews, post-interviews, all of those things, because as we know, children want to please authority figures. Children are highly suggestible. I'll tell you guys a quick story, and a lot of this, I have a 3-year-old child and a 3-year-old son, and a lot of these things you just don't know until you're a parent, right? So he's 3, and we have a little magnet, like little locks on our kitchen cabinets, and they're opened by a magnet. So what we would do, my wife and I, we would take the magnet, we would put it over the lock, and it would open, right? And that was our child protection lock. So what happened was we dropped the little circular thing that had a casing that had a magnet in it, right, to open the lock. The casing opened up on the floor. We could not find the magnet, and my son Chase was there. And we looked everywhere. We could not find the magnet. So my wife and I got a little nervous. We got scared. We said, did our son eat the magnet, right? If he did, that's very serious. So we asked him, and he said no, but, he's 3, right? It's not like he's 10. He's 3 years old. So we said, better be safe than sorry. Let's go to the hospital. So what did we do? We took him to the hospital. We were in the ER. We're in the pediatric ER. We're there. The doctor said, Chase, did you eat a magnet? He goes, yes. She goes, okay, no problem. Let's take him for an x-ray. Let's see. So they did, right? My wife and I are trying to hold it all together, make sure everything's going to be okay. And guess what the x-ray showed? There's no magnet at all. Now that doctor didn't really, that doctor could have said, Chase, what happened? Now, technically it wasn't bleeding. It was a yes or no. The answer to an adult was not suggested. But to our 3-year-old son, when a doctor asked him if he ate a magnet, he said yes. And he clearly didn't. And it's not that, he's a liar or his intentions are to lie. It's just who knows what was going on through my 3-year-old son's mind, right? But going through that process, I turned to my wife and I started talking and thinking, I'm like, and seeing back, well, these things, that's just one example that in my life that now can be used for criminal cases and how children, answer questions. So hopefully that resonates with you folks on this CLE presentation. Well, if we do have, for victim and child victim, right? A child victim, needs to be videotaped for the deposition, okay? And you want to make the child comfortable, but you got to know everything about them. You need to know more about them than their parents, than their loved ones. You really need to investigate them because of, what's on the line. Your client's life usually, right? Their future, their freedom. The only people present should be, you, court reporter, state attorney, and the victim advocate. Do not allow anybody else to be in that deposition room. That deposition room is your sacred place. Sure, there's accommodations being made. You want people to be comfortable because as they're comfortable, they will generally give you more information. But you're in charge of that deposition. That's your sacred place. And you want to ask questions. Right, start off with some easy ones, but then you want to get into friends, school, grades, clubs. A lot of times when we're dealing with children, we have to kind of get back into our minds when we were children. And so there's a lot of self-reflection about, hey, when I was a teenager or a preteen, my parents didn't know a lot of things that was going on in my life with my friends that we talked about, that we were doing. So you have to be able to get deep with especially with child victims, to really get them to open up and let them know, open up, because there's things that they probably hid from their parents, or maybe even hid from the police. And really you want to be able to ask questions that can be tested against other evidence, right? So what does that mean? We're talking timeline. We're talking location. If it's, a molestation allegation, well, how many times, right? Where were they? And don't be afraid to make it slow, boring, monotonous, but detailed. It has to be detailed, because this is your biggest chance to really peel things back prior to a trial. And the point of these depositions, yes, it's it's an additional way to fact find, okay, tremendously, but it's also an additional way to really lay out inconsistencies, not necessarily your theory of the case, but lay out real inconsistencies and really set your case up for trial. And you must do both. Okay, and so we want to know about, well, where'd the evidence go? If there was any evidence, why wasn't it preserved? Anything we can also do to attack law enforcement's credibility. Did they not instruct, an alleged victim, that was timely reported to save and secure clothing, right, and other evidence? So all of those things can really help your case, and you want to, get into the deposition. As we talked about being slow and monotonous, it can be awkward, but slow and monotonous, right, is kind of the tortoise versus the hare. That's what wins cases. That's what it is, in order to be, most effective for your client. Okay, and we put up Rule 3.220 in Florida for the Discovery Florida Rule of Criminal Procedure, talking about deposition of sensitive witnesses. So you folks can read that here, but it's basically under the age of 18, or a fragile emotional strength, if there's an intellectual disability, things like that. But that's the statute for that. But yeah, I mean, these are we're all human beings. The last thing I think any of us really enjoy doing is having a 3-hour or really long, detailed deposition with an alleged victim or a minor alleged victim, going in detail about sex crimes. But it is what it is, and we're here to be advocates for our clients and really, push forth and get the best representation, because a lot of these cases that we've seen have been false allegations, or have been situations where, things just don't add up, right? Or have been situations where the criminal justice system is being manipulated for another issue, such as, child custody, family law issues. We've seen that, and what I've seen especially is prosecutors do not like that at all when they feel they're being manipulated. So that's always, important as well to really, know. One of the last things that I'm going to talk about is on a child victim, a motion to perpetuate testimony. And these are kind of awkward. If you've ever done one, it's very awkward, it's weird, but the more you do them, the better you get at them. And it will look and feel like a trial. It will be played for the jury at trial in a way that they usually, they do stuff like this a lot more in civil. But you have to object, if for the grounds of the motion, and make sure, and really try to prevent that if possible. Okay, because, there's a lot of times where the prosecutors will try to do a motion to perpetuate testimony, and they don't need to do it, right? And so if you can prevent that from even happening, well, that's your best bet, okay? That's your absolute best bet, is to prevent it from happening. So, we always like to say here, you only get so many yeah buts, and it's better to not have to say yeah but. So in this context, it's better to strike, their motion to perpetuate testimony or have the judge deny it than to have to go through this whole thing and process, because it can be awkward. It never is the same in front of a jury than live testimony and feeling the energy during a cross-examination, feeling, seeing full body language, being in the moment, right? For example, this, our Zoom, CLE right here, this is great, but imagine being in a room with me and my team lecturing on this in person, with a packed room where you can actually, feel the energy and see things live, and, really use all of your senses in three dimensions, rather than just seeing a presentation over Zoom that, yes, you can see my body language, but you still can't feel the energy of the room and of all the parties. So that's very important as well. Something that everybody should, be prepared for, especially really primarily on child, on child alleged victim issues with this. And and with that, I'm done with my portion. Our firm, again, here's our information. We help good things when bad people, or good people when bad things happen, so they can achieve their best future. And if anybody wants to keep in touch, we love meeting people. We love talking. We love educating. We love helping. We really believe that we're community and relationship builders first, who just happen to be really good criminal defense attorneys. So that's why we love, presenting these and doing it. I don't see any questions right now. If there's any questions or anybody wants to, has anything at all, I would love to answer them.